Hello friends, welcome to my channel. It's a girl Mercy. If you're a returning subscriber, I appreciate you. If you're new here, please subscribe to this channel, like this video and share it. In this video, I talk about law practice, I talk about tips for excellent practice, I talk about tips that also help new weeks, old weeks, depending on how you want to practice this law. The tips I share in this channel will help you in one way or the other. So today, I'm going to share something very simple, but by request, some people have requested that I do this video. So I want to talk about how to file a process. Well, for some people, they already know how to file a process, but for some other people, they have not been exposed to that area of uh, law administration, or let's say it's part of office management, or even the life of a lawyer in general. So if you're new, if a new week, filing is one of those things you will learn before you are, you can beat your chest and say, yes, I know all that a lawyer is supposed to do. If you are a lawyer who has passed me 5 years, 6 years, 7 years, but for one reason or the other, you have not been exposed to filing, it's also important that you know it, because a day might come when you need to file, so that at least you know the basic steps. There are basic steps, though the process might differ from jurisdiction to jurisdiction, but at the end of it all, the process or the steps revolve around the same line. So whatever I'm going to share with you today will be helpful, whether you're in Lagos, you're in Enugu, you're in Cross River, you're any part of Nigeria, it will help. Now, generally, when you want to file a process, you go to the court registry. Now, for this process that is to be filed, as a lawyer who have been given the process to file, you have to first of all ask yourself, in this era wherein we attach MBA seal, you have to look out for whether the seal is attached. You have to look out for whether the process was properly signed. Now, for the person whose seal is on the process, and you have to confirm it's also the person who is signing, because sometimes in the process you have lists of people whose name appear on the process, but at the end of the day it's only one person that will sign. So it's that person that will sign that his or her seal will be on the process. You have to also look at whether the process is dated. We have seen instances in court where when a counsel wants to move either a motion or adopt a final written address or move, or argue his or her process or application, the judge will now say, counsel, this application before me is not dated. That is when counsel might now say, that was the fault of office manager or whatever. But it is not a nice practice. You have to ensure that every process you have to file is dated. Now, and also ensure that every process you file is signed, because you know that an unsigned document, you know the value of an unsigned document. Another thing you have to also understand is if an affidavit is attached in the applicable process you want to file, you have to also ensure that the deponent sign. Now, this is a very tricky issue. Now, the deponent is supposed to sign before the commission of oath. That is the practice. And in some courts, they have tried to adhere to this principle. So always encourage your client or whoever the deponent is to follow you to court to sign. But if it's an application where you as a lawyer is a deponent, there's no problem. When you get to the commissioner for oath, you sign. Or sometimes if the person that is supposed to sign is not available to follow you, then you must be able to provide proof. Or sometimes they will, in reality, they might want to, okay, why did the person not come and get a valid reason for why the person should sign before, maybe in the office or wherever, before you brought the process to them. But the normal way is that the deponent must sign before the commission of oath. Sometimes during trial, when sometimes lawyers can go out of their way to, to bring up that point that the person did not sign before a commission of oath. You see lawyers asking question, witness, where did you this your witness statement on oath, where did you sign it? The person might say, I signed in my lawyer's office. Or the person might say, I signed in my house. My lawyer brought it to my house and I signed. Now, that is where the lawyer is driving at, to know whether this process was deposed before a commission of oath, which is supposed to be. But that is the right thing. Now, you also understand that in some courts, like the National Industrial Court, Federal High Court, the passport of the deponent is to be used for the filing. So depending on the court you're going to, you need to attach the passport of the deponent on the process. Now, this is not obtainable in all courts, but for those courts that have made it mandatory, you have to use the deponent's passport on the process before it can even be collected from you. Now, when you get to court, you have to locate the court registry. That is where filing is done. First of all, the process has to be initialed. In initialing, the initialing officer will have to write the time and sometimes the date, and will have to sign on the face of the process, which is the original. They always initial on the original because it's the original that you will put in the court file. Okay, when it is initialed, then you now get to the assessing officer. The assessing officer is the person that will tell you how much you will pay for the process. The assessing officer or the costing officer will look at the process, ask you one or two questions. Is there an exhibit in it? How many documents depending? You answer them and they will calculate how much you're supposed to pay. Now, with you having what you're supposed to pay, you will now come to the cashier wherein you make payment. Now, if you are filing the National Industrial Court, they use a remitter system wherein you log into remitter and now generate your RRR number. You now go to the bank and use it to pay. This is a longer process, but it's obtainable there and in some other courts. Now, but for a court that doesn't use the remitter process, you go to the cash office and pay. Now, for those courts that don't even use remitter process, there's an amount of money they collect cash, but if they seize that amount, they will not direct you to go to the bank and pay. When you go to the bank and pay, you photocopy your teller in duplicate in two, and now bring it back. Now, in the court, the bank will now give you a different receipt. It's a customized receipt, though that's what is obtainable here in Lagos. But in other states, the bank might also give you a specialized receipt or just give you a teller, which you will now bring to the cash office. They will now issue receipt to you. Now you take back your process to the person who initiated for you. Sometimes you have an initiating officer separate from the commission of oath or the ACR or whoever is in charge. Sometimes not even the ACR. Someone might be designated to be doing the commission of oath work. Now, or someone will be designated to do the initialing. After you have paid, you return back to the person who initiated for you. Now, the person, if it's a commission of oath, you will now sign on the oath section of your affidavit, if there's anything like that, and now fixing the date. Or sometimes if the documents are bulky, they will do the original by signing on the originals while you fill in the dates. But some other time, some of these commissioners want to do that by themselves. They will sign on the oath section and fill in the dates. Now, if you have any document or exhibit, they will ask you, or sometimes because of the crowd, you have to remind them. Then you fold those parts that the documents are of the exhibit. They have to stamp on those the back of those documents. But sometimes when the crowd is much, you that is filing, there is an assumption or presumption that you're supposed to know what to do. So what you can do, just like they release their stamp, you now stamp at the back of those documents. Or sometimes They will stamp the original and now ask you to follow stamp where you see the stamps of the original on the duplicate. After which, in some courts, you take the original document by yourself and go and drop it in the court, because the original belongs to the court. That's the court's copy. Now you now go to the bailiff for service, where you sort out who are you serving. You mobilize the bailiff to serve. Now, if it's a court like National Industrial Court or the Federal High Court, sometimes, depending on your jurisdiction, when you have finished filing, they will only give you your own copy. They will sort out the issue of the original to be put in the court file, the bailiff copy for service. But they will have to ensure that you go to the bailiff section and pay. Courts like that already have specific amount for different area within that jurisdiction. So if depending on where you're serving, they already know how much it will cost you. So they will tell you, you pay for service, bring your receipt for service, and now go back to the registry to show that I've paid for service, and they will collect it from you. You now fill an acknowledgement copy to say that I have received a copy of so process I filed this day. You now collect your own copy, and they will collect the remaining. There's a process for the court. The registry will take a copy, then copies for service, and then they will give you your own copy. Now, sometimes as a lawyer, even senior lawyers, sometimes when they want to file, they don't know how many copies to do. This is another thing you need to know. What you need to do is you have to count. The court will always have one copy. At least you can count one copy for the registry, but sometimes they collect two. Then you have to count how many people you're serving, then count each of them, and then your own copy. Sometimes some bailiffs will collect an extra copy for they say they will use it to do proof of their acknowledgement copy for the people they are serving. Depends. So whenever you're going for filing and you're the one preparing the process, or you're in the position to tell whoever is preparing the process, let the person always have an extra one to the process by the venture, so that you won't go there and they ask you go and make more copies, or you won't have a copy, because it will not make sense. After filing, you will not have a copy, because sometimes you go to court, you will not see that. Sometimes you go to court, you will not see that maybe the process have not been moved to the court, or the court will say, I cannot find your process, or maybe there's a mistake. Maybe you couldn't tell them the right court. Maybe they misplaced your process in another court. Then you have to now give the court your copy. So always try to have an extra copy of any process in your file. Don't have one copy, always have two. Now, for courts like National Industrial Court, like at the registry, they will ask you which court. These courts are known by their numbers, so you need to know the judge's name, depending. They will ask you for the name of the court. You tell them, then they will now write it in front on the front of the process. This will help them so that when they're trying to sort out the processes, they'll be able to sort it out. But if you make a mistake as to the court number or the court name or the name of the judge, it will be disastrous for you, because by the time they will sort it out, maybe your matter would have come up and the process is not in the court file. Now, for courts like the High Court, wherein the remitter system has not been introduced, or is not in use, after you have made your payment, you are the one that will take the original copy to the court, take the ones for service to the bailiff, mobilize the bailiff for service, and take your own copy. It is also up to you to be on the bailiff for proof of service, because sometimes when applications are sought to be moved in court and the court is asking, counsel, have you served? So your proof of service is what will help you, or to show the court that you attempted to serve or you have served, and this is the proof to enable you move your application. So filing is very easy when you understand the dynamics. Sometimes people go to file and the oath section was not signed by the Commission of Oath. Then is it defective? So before you leave the registry, open your process, check out, has the proper places been stamped? Have my exhibit been stamped? The document, have they been stamped? Before you leave. So I just hope that this video will have helped you to have just a brief history, rundown of how to file a process. It's very easy, but you have to learn it. It's not something, because if you rush through it, you make mistakes, especially when you are filing bulky process. Now, filing at the court of appeal too is another pot of soup. It's a different ball game altogether, because that at that point also you generate the RRL through the remitter process. And you, though when you ask questions, don't be too pompous to ask questions. Ask questions, and you'll be taught and you'll be guided. Thank you for always watching this channel. If you have not subscribed, please subscribe. Thank you very much.